Good morning and a happy Monday, everyone. This, unfortunately, is take 4 of my video recording today. I'm not on the top of my game. So, this is a continuation from last week where we were talking about the importance of filing a patent. I have a lot of people come to me and say, Shalini, is it okay if I don't patent my invention? And I say, sure. But here's how the situation is going to pan out. The first is large companies that have the advantage of economies of scale are going to mass produce that invention which you would have otherwise patented and flood the market with a product that is similar to yours. And you're going to be at a disadvantage. The second is smaller companies, while they don't have the economies of scale to their benefit, but they do have the fact that they don't have to recoup R&D costs, raw materials that went into trial and error, the trial and error period with various prototypes that you had to struggle with. So they don't have to recoup all that initial costs and they can sell the same product at a much lower rate. So you're at a double disadvantage. The second point is that anytime you want to sell your invention, license it, monetize it, technology transfer is in talks, they're going to want to see a patent certificate. They're going to want to see the paperwork. Would you buy a piece of land if I told you, hey, this is my piece of land, will you buy it? Will you buy it without seeing the sale deed? No, right? It's the same thing with intellectual property. They will want to see the sale deed, or in this case, the registration certificate. The third point is that if you don't patent your invention, and let's say you're already selling it, someone is going to make improvements, minor improvements or major improvements, and file for a patent. At which point they're going to come back to you and say, hey, you know what? You're infringing on my invention. So license it from us or back off. You're going to be again at a disadvantage. And the fourth and final point is that you could say, hey, I'm already going to publish my innovation. So that way everyone else is going to be, this becomes a prior art for everyone else. And that is called defensive publication. It is a very valid defense. But keep in mind that you're very sure you don't want to patent it at a later date. Because if you do a defensive publication and try to be a prior art for others, make sure that you don't end up becoming the prior art for yourself. Because if you do want to patent it at a later stage, you become your own prior art. So keep in mind that you don't have to file for a patent, but if you don't, then these are the pros and cons. So if you want to analyze if you have an invention that you need to get patented or not, what should be the strategy, what should be your path forward, come talk to us. Have a great day and a week ahead. Ciao.